Welcome to Wealth and Honor Take 5. Today I'm going to address a question I received, which is, am I responsible for losses in my parents' accounts due to the coronavirus crisis? Now, this is really a two-part question. The first part of the question has to do with the role this person may occupy with regards to their parents' accounts. A fiduciary is a person responsible for another person's property, and the law holds this person to a high standard of behavior. A fiduciary is to act at all times in the interest of the person that has entrusted them. Now, a person can be in an official fiduciary capacity as a power of attorney or as a trustee of a living trust, for example, or they can be a deemed fiduciary, which is sometimes called constructive trust, because it arises out of a court action in which it is determined that someone was in a trusted position even if they weren't officially named. So if you are a named fiduciary for your parents, then there is a responsibility that goes with that position. Now, while I cannot answer whether you are legally responsible, I can offer 3 tips that will help you if ever your actions are brought into question. The first tip is to document any and all decisions that you make regarding your parents' accounts. Document conversations you have with them, document conversations you have with the advisor who may manage the accounts, document the decisions you make regarding the accounts and why you felt those decisions were the best decisions when you made them. Document, document, document. The second tip I'll offer is to communicate. Communicate frequently and clearly with anyone impacted by your decisions. This includes your parents, certainly, but it also includes anyone else who might be impacted by your decisions later on, or who might bring your decisions into question. For example, if your parents have limited capacity, you might want to include your adult siblings or an objective third party in your discussions. I have found that most legal complaints against fiduciaries are rooted in poor communication, so communicate as much as you can with others. The third tip is to understand the standard by which your actions will be viewed. Nearly 200 years ago, a Massachusetts case involving Harvard College resulted in what is known as the prudent man rule. That rule, although modified over the years, is still used today, in many cases to determine whether or not a fiduciary acted in the best interest of the party who entrusted them. In that case, Justice Samuel Putnam directed trustees to, quote, observe how men of prudence, discretion, and intelligence manage their own affairs, not in regard to speculation, but in regard to the permanent disposition of their funds, considering the probable income as well as the probable safety of the capital to be invested. So in other words, courts look to whether or not a prudent person would have done the actions that were undertaken when they are looking at whether or not someone acted on behalf of the person who has entrusted them. So if you are a fiduciary, officially, or would be deemed to be one, follow these 3 guidelines to protect yourself as much as possible from liability. Now, to address whether losses specifically tied to the coronavirus would make you any more vulnerable to liability, I'll only add that at least you're in a large company. As long as you are acting in good faith, no one could have foreseen the losses that rapidly occurred in just 4 weeks from the highs of the S&P 500 in mid-February to their current lows that occurred in late March. If you have documented your decisions and communicated as best you can, then it's unlikely that you would be held responsible for the losses they have experienced so far. Nevertheless, if you feel that you do have potential exposure to liability, I recommend that you get in touch with a licensed attorney in your state, experienced in estate litigation matters, to discuss your situation. Well, that's all the time we have for now. Thank you for tuning in, and stay safe.